Yes, so welcome to our briefing on outsourcing and the important steps that you need to take prior to the 31st of March 2022. Whilst everyone on this call is or has been a client of Creed Solicitors, I don't think I recognise all the names. I'm not sure I've spoken to everyone individually, so I thought it'd be worthwhile just me introducing myself. My name is Richard Creed and I am the owner and managing director of Creed Solicitors. Creed Solicitors has been in business for 6.5 years, and we specialise in advising payment institutions and electronic money institutions on their legal obligations and providing them with legal support. That includes drafting terms and conditions, negotiating contracts, which is what we're going to be talking about today, and I also do some work with share purchases for regulated entities as well. So those are my main focus areas. Today's talk is going to be on the important steps you need to take before the 31st of March 2022 in relation to outsourcing. Hopefully, if you haven't started this already, you will benefit from this talk because you can go away with a bit of a plan to try and do everything you need to do before that deadline, and you'll have more of an idea of what those requirements are. So what are the FCA's requirements in relation to outsourcing? So the main requirement is that you need to comply with the European Banking Authority's guidelines on outsourcing. Now that document is some 120 pages long, and I'm going to run through in this talk what the obligations are for the contracts that you enter into with your service providers that are providing you with outsourcing activities. And I'm also going to talk to you about what needs to be done on the 31st of March 2022. Now, for those of you that don't know, the FCA have asked payment institutions and electronic money institutions to tell them on the 31st of March 2022 if any of the outsourcing arrangements which they have entered into, which are critical or important, don't meet the EBA's guidelines. So in order to sort of flesh that out a bit, it's obviously important to understand what outsourcing is. So outsourcing is an arrangement between the payment institution and the electronic money institution and a service provider, by which that service provider performs a process, a service, or an activity that would otherwise be undertaken by the payment institution or the electronic money institution itself. We'll just say that again to let it all sink in. So it's a relationship between the entity that you work for and a third party. It's fairly basic, a service provider. You've got plenty of service providers, but that service that they are providing is only outsourcing if ordinarily you would conduct that service in-house, but you've asked a third party to do it. So what are examples of outsourcing? Well, cloud computing is an obvious one. In maybe a decade or two ago, it was common for people to have hard drives in their office and keep their confidential information and personal data on that hard drive. Now, I'm sure everyone on this call uses cloud computing services, so you outsource that to a third party. Other outsourcing arrangements might include if you use software as a service, like an accounting package such as Xero, and other such packages. Transaction monitoring as well. I mean, you could do that in-house. You're obliged to do that yourself. But most people use a tool or a third party to carry out that transaction monitoring for them. In terms of finance, payroll and bookkeeping is something that you could do in-house, but actually most people send that to a third party who specialise in it. They haven't got the expertise in how to do that. One important point to note, which some people may overlook, is that intragroup outsourcing is still outsourcing. Just because you have a sort of, possibly if you're part of a larger group, you have one entity which might provide HR services to the entire group or payroll services to the entire group. In relation to you as the payment institution or the electronic money institution, if you're asking that group company to do services for you, that is still outsourcing, and your contract with that party still needs to comply with the European Banking Authority guidelines. Examples of activities not considered outsourcing, like telephone and internet service provision, Obviously, you can't give yourself access to the telephone network or the internet without a third party. So by engaging with those people, that's not actually outsourcing. Now, that's obviously not to say that access to telephone and internet is not important for your business. It's absolutely essential. And you do need to look at the risks that are involved in engaging with those service providers, but that doesn't fall within outsourcing. And it's probably less critical to look at those contracts in terms of the 31st of March 2022 deadline than it is to look at the critical important outsourced contracts. So obviously you can't provide yourself with electricity, gas or water. So engaging with those suppliers isn't outsourcing. You can't provide your own statutory audit. You have to get an independent firm to do that. So that engaging with accountants isn't outsourcing. You can't, access the credit reference databases. So you need to engage with a credit reference agency. That's a service. That's not outsourcing. Provision of some legal services isn't outsourcing. For example, you can't give yourself a legal opinion, or you can't go to court yourself because solicitors need a live audience. If you engage a solicitor for that, that wouldn't be outsourcing. I think technically, if you engage a solicitor to review contracts on your behalf, that could fall within the definition of outsourcing because technically you could review those contracts in-house. Helpfully, they have said that cleaning, gardening and maintenance of an institution's or payment institution's premises isn't outsourcing, even though technically I think it is. I mean, we could all clean or garden or maintain property, perhaps not very well, but by giving it to a third party, that is outsourcing. But helpfully, they said that doesn't need to comply with the EBA guidelines. So there's a higher threshold that you need to comply with if the outsourcing is critical or important. There's sort of extra clauses that need to be in the agreements to mitigate the risk of those outsourcing arrangements being critical or important, and also the critical or important contracts are the ones that the EBA want you to report about by the 31st of March 2022. So it's obviously essential to work out what outsourcing arrangements are critical or important. And I've set out the definition from the EBA guidelines on this slide. So where a defect or failure in the performance of the third party would materially impair payment institutions or electronic money institutions' compliance with the conditions of their authorizations or their other obligations under PSD2 or the Electronic Money Directive, then that is critical or important. Or if its detriment would affect the PI's or EMI's financial performance, or soundness or continuity of the banking and payment services activities, then that is critical or important. If, for example, you couldn't facilitate any payments as a result of your third party not fulfilling its duties, then that is a critical or important function, outsourcing. So you would need to make the contract with that third party comply with the EBA guidelines. If operational tasks or internal control functions are outsourced, that will be critical or important unless you've done an assessment and you don't think would have an adverse impact on the effectiveness of the internal control function. Banking activities or payment services that require authorization by competent authority is also critical or important. So one that springs to mind is if you have a separate card issuer issuing cards which are linked to your payment accounts or electronic money accounts, that would be a critical or important service that would, under contract with that entity, would need to comply with the guidelines. So what are the important steps you should take to try and meet this 31st of March 2022 deadline? If you haven't started already, I don't know if everybody has or has not, but if you haven't started, the first starting point is to ascertain which third parties actually provide you with services. Now, the best way to do that is probably to talk to your accounts department and find out who you pay. It's not a completely foolproof plan, but the chances are if you're paying someone, they're providing you with a service, and people who provide you with services won't do it if you're not paying them. So hopefully that should get you 80% of your service providers, if not absolutely all of them. So once you've got, but you know who these are, like create a list and work out, are they providing me with an outsourced service or are they providing me with a service which doesn't amount to outsourcing in accordance with the definition? You'd also find and centrally store, if you don't already do so, all the contracts with these service providers so that you can review them and conduct a gap analysis. Once you've got your list of all your outsourcing contracts, your outsourcing service providers, I think you just sort of copy and paste that into a new register of outsourcing arrangements, which the EBA guidelines say that you must put in place. The sort of information that needs to go into this register is a reference number for each outsourcing arrangement, a start date, a next contract renewal date, and an end date for the contract, a brief description of the outsourced function. You need to assign a category to each outsourced arrangement, i.e. is it IT or HR or payments related. You also need to put down obvious things such as the name of the service provider, its corporate registration number, its registered address, and other relevant contact details. You also need to put down the country or countries where the service is to be performed. That may or may not be different to where the registered address is, so you need to note that down. And you also need to write down whether or not the outsource arrangement is critical or important. That's important for obvious reasons, but also because if it is critical or important, you need to put more information in the register. And that additional information includes the date of the most recent risk assessment and a brief summary of the main results. It also needs to set out which individual or decision-making body within the payment institution or the electronic money institution actually signed off on this outsourcing arrangement. You need to state the governing law of the contract, the dates of the most recent and next scheduled audits where applicable, the names of any subcontractors that your service provider is subcontracting some of the services to, and an outcome of the assessment which you'll need to undertake of the substitutability of that contractor. Obviously, if a contractor is very easily substituted, then that's less risky for you. You know, if your contractor shuts down one day, can you set up again on the day after without there being any significant interruption to your services? If so, then that would be relatively low risk. Sort of card issue example I gave before, it will take quite a long time to exit one card issuer and join a new one. So you'd want, you know, maybe 6 to 9 months of a transition period after termination of a contract to find a new supplier and extract all the information you need to extract from your existing supplier and transfer it to the new one. So substitutability is a very important risk that the FCA want you to look at. In that vein, you need to write down in your register a list of alternative service providers. And they also ask you to put in the estimated annual budget for the service provider in question. So as I said, after this briefing, I can send out an Excel sheet I've set up, which puts down all the categories that you need to put in the risk register, and then you can populate it as you choose, or just use it as a tool to create your risk register if you haven't already done so. So once you've got your list of services, your list of outsourced services, and then you register, the next step is to conduct a gap analysis on the contracts against the European Banking Authority requirements. Now I'm going to run through what those requirements are briefly later on in this briefing.
Richard, sorry to interrupt. Can I ask a question? This is Mukesh. Can I ask once? See, do we have a EBA requirement? Is it some Excel standard requirements are there which needs to be mapped against the gap for the gap analysis?
Yeah, there's a requirement. I've got the sheet here. It's in paragraph 54 of the EBA guidelines.
Okay. No, I'm asking, is there any Excel or something? Is this template kind of they have given which we need to fill up for gap assessment, or based on the guidelines only we have to derive from our own?
Line's not great, but yeah, there's a list of things that needs to go in the contracts you have with the third party outsourced providers, and you just need to review the contract and find out if all the provisions that need to be in there are in there.
Okay. Continue. Yeah, continue.
Does that answer the question?
I was asking for performing the gap analysis.
Yeah.
when we had a list of all the outsourced vendors who are material for the organization. So is there any template given by EBA, or we have to find out what are the requirements from the EBA guidelines and then map against the existing practice?
Well, yeah, all the requirements are set out in the European Banking Authority guidelines. I've actually created a sort of internal document which has a list of them. It's just a big word table basically.
Okay.
So I can provide that to you if you want me to, and anyone else is welcome to.
Sure.
One of our services would be, if you don't want to do that yourself, is to conduct a gap analysis on your behalf, or we can provide you with the Word document. I don't mind doing it.
Sure.
Okay. So yeah, you need to conduct a gap analysis on the contracts against the EPA requirements, and then obviously amend the contracts would need to be amended. And if you haven't started this already, it probably seems like quite a daunting task. So we need to prioritize which are the most important ones to conduct the gap analysis on, and deal with the other ones later on. So how do you prioritize which outsourcing contracts to review and amend? Obviously, the critical or important ones are the ones that the FCA are going to ask about, have asked about and want you to report upon on the 31st of March 2022. If you don't think you can get all the critical and important contracts amended by that date, I would suggest that you focus on the ones that were started, reviewed, or amended since September 2019. And this is because you're actually obliged to make sure those contracts comply with the EBA guidelines from September 2019 if they were started, reviewed, or amended since that date. So if you can't get all of them done, at least you could go to the FCA and say, well, listen, we've made sure that we made these changes on contracts that were started, reviewed, or amended since September 2019, and the ones which weren't are still in progress, and we hope to have them finished by, for example, June. That's obviously much better than not having done the work. It's not ideal, but we've only got, I think it's less than 9 weeks before this deadline. So if you do need to prioritize, that's how I would prioritize which contracts to amend. So yeah, as I said, first priority would be critical or important outsourcing arrangements that were started, reviewed, or amended since September 2019. Second priority, critical or important outsourcing arrangements that were not started, reviewed, or amended since September 19. Third priority, now this still needs to be done. It's just the FCA aren't asking you to report on it on the 31st of March, so it still is important. You need to do the gap analysis and update the outsourcing arrangements that were started, reviewed, or amended since September 2019, which aren't critical or important. And after that, it will be just the ones that were not started, reviewed, or amended since September 2019. And I would also put on your roadmap to completing this project that arrangement with third parties which do not amount to outsourcing still need to be looked at, still part of your operational resilience. We touched upon earlier on telephone or internet service providers, and obviously if everyone's still back in the office and that goes down one day and you're sort of a very sales-led team, the telephone lines or the internet goes down, that's just going to be devastating to your business. So although it's not technically outsourcing, it would not be a bad idea to look at those contracts and see where there are gaps between the EBA's requirements and your contract, because it's a good checklist for what risks are with third-party service providers. So yeah, I've got a question. Come in, Amazon provider, cloud computing service, how would we be able to negotiate a contract with them? Obviously, Amazon are a huge provider and you might think you hit a brick wall with them, but you might be surprised. Well, I would imagine that they might have an addendum which would attach on to existing contracts they have with financial institutions, which would supply, satisfy the EBA guidelines, because they must have so many financial institutions across the UK and Europe which have this requirement. I doubt you're the first person to have asked. So perhaps some of the bigger suppliers might be easier to get these amendments through for. Might not be able to sort of, for example, go and audit Amazon, obviously, but if they have a standard addendum for financial institutions, which ticks 70% of the boxes, at least you can tell the FCA that you have done all that you have been able to do, and that's much better than not having tried. So yeah, I'm now going to run through what the EBA guidelines set out for the contract with your outsourced service providers, those which are critical and important. They fall under sort of four main headings. There's sub-outsourcing, security of data and systems, access, information and audit rights, and termination rights. So in terms of sub-outsourcing, you need to find out if the sub-outsourcing of critical and important functions is actually permitted under the contract. Obviously, if you enter into a contract with a service provider, you will carry out a bit of due diligence on that service provider. However, if that service provider sub-outsources 90% of the contract to a third party, it's probably more important that you carry out the due diligence on that third party. Using the Amazon example again, just to sort of, I'll exaggerate the point to make the point, but if you had a contract with Amazon Web Services to do your cloud computing, and they actually sub-outsourced the entire thing to Mickey Mouse Limited from a far-flung jurisdiction without very good data protection laws, then essentially your contract is with Mickey Mouse Limited and they're looking after your data. So you need to have tight controls over what sub-outsourcing is permitted, and do your due diligence on the sub-outsourcing, the parties that are providing the sub-outsourcing. So if sub-outsourcing is permitted in your contract, you need to find out if what is being sub-outsourced is critical or important. And if it is, then you need to record that in your register of outsourced arrangements. If it is, to write down and make clear any activities that you're excluding from sub-outsourcing. And if it is sub-outsourced, you need to put in any conditions to be complied with. And those might include that the sub-outsourcing party is subject to the same data protection obligations and confidentiality obligations and IT security obligations that your service provider has to comply with. So you put the onus on your service provider to make sure that contract with the sub-outsourced partner has all of those terms and conditions in their contract. You also need to make sure that the service provider is making sure that their contractual obligations are met and is responsible for everything that the sub-outsourcer is doing, because you don't have a contract with the sub-outsourcing party, so you can't sue them for breach of contract. Your best recourse is to the service provider that is providing you with the outsourced services. You also need to get your service provider to ask for your consent before sub-outsourcing, or at the very least provide you with notification for any sub-outsourcing arrangement change after you enter into the contract, and that will give you time to carry out a risk assessment of the sub-outsourced party and give you time to object if you're not comfortable with who that third party is, and give you a termination right basically if you're still not happy and they haven't made you feel comfortable actually after you've notified that you object to the sub-outsourcing. In terms of security, data systems, you need to make sure your service provider complies with appropriate IT security standards. You also need to define data and system security requirements and monitor their compliance with those requirements. As part of this exercise, it would also be good to sort of integrate your GDPR compliance needs. Find out where your personal data is going, what controls are held over that personal data, make sure you've got the right contracts, the standard contractual clauses in place. For example, if you have to transfer the data out of the UK or into the EU, I think in the EU it's deemed adequate now, but you need to get someone to sit down and work out where your personal data is going, and do you have the right to send it to those places? Is it all legal? And also what the EBA guidelines are saying is that if you are sending your data to a country which has lower standards for data protection than the UK does, you need to make sure that they step up their data protection compliance to the UK standards rather than just sticking to their national data protection compliance in order for you to be compliant with your obligations. You need to monitor the service provider's performance on an ongoing basis. And to do that, you need them to give you agreed service levels and precise targets. You also need to put the onus on them to report to you any development that may have a material impact on their ability to carry out the service, and submit reports to your internal audit function. You should also specify if you want your service provider to have mandatory insurance of any kind. They need to implement and test business continuity plans. And you need to make sure that there's provision put in place for if your service provider goes insolvent. I mean, how do you get your data back? Your service provider also needs to cooperate with the FCA or the ICO. I mean, if you just take a step back, the FCA wants to regulate you as a payment institution or an electronic money institution. If you're saying, I'm not going to undertake this service that I could otherwise do, I'm asking a third party to do that on my behalf, the FCA would naturally want to be able to contact that third party you're going to be speaking to and using as a service provider, so that they can regulate all of your service appropriately. Access information and audit rights. You need to ensure that your internal audit function is able to review the outsourced function using a risk-based approach. You also need to ensure that the FCA has information gathering and investigatory powers. With regard to critical or important functions, yourselves and the FCA need to have full access to the relevant business premises and unrestricted rights of inspection and auditing related to the outsourcing arrangements. What you are allowed to do, I mean, obviously carrying out an audit is quite an onerous task for that service provider. If every client of theirs is able to carry out an audit yearly, I mean, just spending their entire lives just facilitating people auditing them. What you can do is rely upon pooled audits, organised jointly with other clients of the same service provider, or you can use third-party certifications or rely upon those, or third-party audit reports. But obviously need to assess how good the third-party certification is. There's obviously very well recognised ones, and you're not allowed to rely solely upon these sort of internal audit reports or third-party certifications over a prolonged period of time. You need to retain the right to carry out your own audit. If the outsourcing arrangement carries a high level of technical complexity, then you need to ensure that people who are carrying out the audit on your behalf have the expertise to carry out that audit effectively. Termination rights I touched upon before. That's possibly the most interesting part for me. You need the ability to terminate an agreement with your service provider if they have breached applicable law, regulations, or contractual provisions. That's not controversial and should be in most contracts. What I mentioned before was that if there are material changes to the outsourcing arrangement or the service provider, then you need to be able to terminate as well. If you're not happy with that. There are weaknesses regarding the management and security of confidential, personal, or otherwise sensitive data. You need to be able to terminate. If the FCA or the ICO tell you you have to terminate the contract, then you need the right to be able to do that in your contract. And that's something that isn't always in the contracts that I review before I've amended them, obviously. So you don't want to be put in the position where the FCA, apart from just having to apply the EPA guidelines, you don't want to be put in the position where the FCA says you have to terminate this contract, but there isn't that right to terminate in your own contract, and there's nothing else which uniquely fall in with as a cause for terminating the contract, because otherwise you may have to terminate without due cause, and that might leave you open to an action for damages from your service provider. So it's important not only from a compliance point of view to have these in, but from a practical point of view. As I mentioned before, the outsourcing arrangement should facilitate the transfer of the outsourced function back to yourselves or to another service provider. So you need to allow for time if it's not an easily substitutable service. For example, if it's terminated on the 30th of January, you might say, well, actually, this isn't an easily substitutable service. I need 9 months to find a new service provider. You would want in your termination agreement with termination provisions with your original service provider to say, upon termination, you provide us with transitional services for the 9 months until we can find a new provider. And we're going to put a fixed cap or an hourly rate on the amount of time it takes your staff to take the data we need to transfer to our new service provider over the course of that 9 months. If you don't have those provisions in, it's quite easy for your existing service provider to hold you to ransom for a bit. They can either turn off the services on day one, which might catastrophically affect your business, or they might charge you a premium to continue with the services, or they might say, yes, we can give you your data back, but it's going to cost you 10 times the amount that you would have paid if you negotiated that at the time or amended it when you've got a good relationship with your service provider. So those are the main EBA requirements that need to go into contracts. I obviously haven't covered absolutely everything, but those are the headlines. So, how can we help? If you're having trouble working out whether a service that you're being provided amounts to outsourcing and it needs to comply with the EBA guidelines, we can help you with that. We can also help you work out whether the outsourced service is critical or important or not. More than happy to have a call on that or provide you with some written advice. You can also provide gap analysis of your contracts with service providers against the EBA guidelines. If you feel that you've got far too much work to do to meet the deadline of 31st of March 2022, you can let us do that on your behalf. We'll provide a fixed fee to review the contract once we've seen it and let you know where the gaps are. Once you know where the gaps are, you can go back to your service provider and say, listen, there are these gaps in place. What are we going to do about this? We've got a deadline of the 31st of March 2022 coming up. And obviously we can help you negotiate the new contracts with the new service provider, put in place appropriate wording that satisfies the EBA guidelines as much as we can. I suppose one point to make, which is worth making, is that the EBA guidelines, whilst this is a pain for you all, and I don't underestimate that at all, what the EBA guidelines do is put you in a stronger negotiation position with your service provider than you otherwise would have been. It's no longer, I want this, you want that. You're a massive service provider. We're possibly a relatively smaller firm, and they would let you negotiate the standard terms. You can say to them, listen, it's not me that wants this. I have to have it to comply with the EBA guidelines. And this will give you a much better contract. You will be able to have better termination rights than the other way it would have been. You will be able to have transitional services after the contract has been terminated. You'll be able to audit them and all the things I ran through, basically. So whilst it is an administrative nightmare for you, potentially, it does put you in a better negotiating position for existing service providers and new ones.